Hi everyone, I want to talk to you about this case that came out yesterday, September 17th. I don't know what day you're going to see this video. It's a little bit longer than normal, but it's a big case. It's a bombshell. You need to listen to it, read it, and hear the four main points of this case and what happened in it. This is a landlord-tenant dispute, went up to the Court of Appeals, and landlords, you've got to beware. Property managers, you've got to beware of what can go bad if you don't take care of your property. In this case is exactly the thing that you have to be concerned about. I know most landlords do a great job. They take care of their properties, they maintain them and everything, but this case is going to embolden plaintiffs, tenants, and tenants' lawyers who take cases on contingency because there was a claim for $60,000 of attorney fees on a 3-day jury trial. Okay, this case started in small claims court, and I'm going to read some of my notes to you because it's so complicated. But this case started like most landlord-tenant cases, a breach of contract filed by the property manager on behalf of the owner for like 1 month's non-payment of rent, right? So it was a minor case. It's like no money at all, right? And then the tenant got a lawyer. They lawyered up. Yeah. And then they countersued. They took it out of small claims court. They demanded a jury trial, right? So big time. All of a sudden, the equities and the litigation risk is significantly different. And the case progressed all the way to trial, a 3-day jury trial. The jury agreed with the tenant. Right? That there was no breach of contract by the tenant. They didn't do anything wrong. Who did something wrong? The landlord, because the landlord failed to maintain their property and failed to make repairs within a reasonable amount of time. Okay, so let's start at the beginning, right? Four main issues. Number one, did the landlord fail to maintain the premises in good condition, good and proper order? They were responsible under the lease for providing water and gas, right? So guess what? There was extended periods of no heat in the building during cold weather, frequent heating outages during those cold weather, and the jury awarded 6 months of damages for just that on that issue, $4,500. It was only $750 a month rent, right? And so they gave him 6 months for not having proper heat. So they found that there wasn't proper heat because it kept going on and off, right? Number two, there was a claim under the statute 32-31-8-5 Indiana Code. This is the statute that tells landlords, here's what you have to do. Here's what you have to do to be a landlord and provide housing to another person. And there's like a whole laundry list of things that a landlord has to do. There's a statute for the tenants also, but this is the landlord's ones, right? And a couple of them were requiring reasonable effort to keep the common areas clean and in proper condition, and also provide and maintain the plumbing systems and a reasonable supply of hot and cold water at all times. So what happened is the water heater in this building went out, and it kept going out and it kept going out, and the tenants were complaining, and this tenant complained, and they'd get scalding hot water one day, and then in the middle of the shower it'd go freezing cold, scalding hot, freezing cold, right? On and on and on all the time while they're taking a shower, right? So it's not just, hey, whatever. It's significant. There was also a water pipe in the common area hallway above the stairs, and it had been dripping, right? Drip, drip, drip. Finally, the water pipe bursts, the ceiling caves in, and water is just gushing out. It's going everywhere. It's going down the first floor, the second floor, the third floor stairwells, and there's water everywhere. There's up to a half an inch of standing water. It takes more than a week to fix that, right? It took how long? Over a week to repair that. Other plumbing repairs took 14 days to repair after notice to the landlord, right? There were no caution signs put up, no tape, around the area as a barrier, no mopping up by the landlord. They just let that water run, right? So a major, major problem uh, and the landlord didn't really attend to it. So at the end, the third issue was that the court, and so the landlord was liable for all of that, right? They were liable for not providing heat. They were liable for not providing proper plumbing, right? In just a couple weeks, right? A week, 2 weeks, they said they ordered a part and it didn't get there for a few extra days. You know, the tenant said, look, you should have overnighted this. This was a serious problem. You should have taken more drastic measures. And the jury agreed. The jury said, no, you've got to do a better job of caring for your properties. We're going to find you liable as a landlord for not doing what's reasonable under the circumstances. And that sounds like that's a hard, a little bit squishy, literally, squishy term. But here we've got the facts and what happened. 14 days, the other one over a week. So that's a pretty narrow time frame to fix things sometimes. So landlords, you've got to be aware. You got to know that this case is out. You got to know how serious it is. So the third thing was, and I'm going to get to number 4, was really big. Judges bias. The trial court may be biased against the tenant. So the court ordered attorney fees for violating the statute that I was just talking about. The trial lawyer presented testimony and evidence that his reasonable attorney fees for bringing this cause of action, litigating it all the way through a trial, was $59,000 and some change. And the court said, no, I'm not going to give you $59,000. I'm going to give you $2,000. That's it. That's what I think is reasonable. So up on appeal, the Court of Appeals didn't like that. The Court of Appeals said, look, this guy took this case on. I don't know if he got paid or not by the tenant. I don't know what the responsibilities were. It doesn't matter that it was only a $1,700 case to begin with. It doesn't matter how small the damage award you get is. If you prevail, depending on the work you had to put in to get that result, then you can get compensated for that properly as an attorney, and $2,000 isn't even close to cutting it. They said it's far too small an amount to recompense an ultimately successful plaintiff in a 3-day jury trial. That's powerful language that we need to be aware of on the landlord side. And if you're a tenant, same thing. You've got some very powerful ruling there. Finally, issue number 4, the judge's bias. There were statements made before, during, and after trial that the tenant was objecting to the trial court, the judge himself, saying he was biased, prejudiced against him, all these different things. And they somehow waived that issue on appeal. But the Court of Appeals said, hey, wait a minute, we're not just going to ignore this. We're going to use this as an opportunity to tell you trial judges what your duties are. And here's what it is. A trial court has an obligation under the Code of Judicial Conduct to be patient, dignified, courteous to litigants, courteous to jurors, witnesses, lawyers, court staff, court officials, and others with whom the judge deals in their official capacity. And so that's a big hand slap to the judge, and it's a very serious matter. And I think we're going to see that trickling through the behavior in the courtroom, and judges are going to be more careful and be more maybe even-handed. And this opinion, this is a big opinion. I've taken a lot of time on it, more than I normally do, but I want you to get the main points out of it. I've posted the link, not the link, but the name of the case, so you can read the whole thing. It's 24 pages. It's kind of, it is a lot of legal mumbo jumbo, right? Because it's very procedurally oriented. But if you read the case, you'll see the main holdings going through there and what happened exactly as I stated it. So landlords, beware. This is a big case, one you need to know about, and one you need to be taking extra effort to care for your properties, not let them be neglected, and not let them fall into disrepair and not attend to those repairs promptly under the circumstances. That's it. Have a great day. Thank you so much.